Surely it can't get any worse than deploying the National Guard for the protests. And now they're deploying the Marines. What? As we've discussed a lot in recent videos, the Trump administration has taken a very aggressive and questionable legal approach to immigration enforcement. Recently, Los Angeles County, where nearly half of the population is Latino, has become a particular target of Immigrations and Customs enforcement. Under pressure from the Trump administration, ICE has ramped up enforcement, including a record-breaking 2,200 people arrested on June 4th. And this is still apparently not enough for White House Deputy Chief of Staff Stephen Miller, who has proclaimed that ICE must now arrest 3,000 people per day. Now, we've covered ICE's questionable tactics, but it's worth noting that many of these immigrants are being arrested when they're actually trying to comply with the law by appearing at immigration appointments. As we've talked about, some of them were being shuffled around in various detention centers around the country, others were being shipped off to Salvadoran torture prison or South Sudan with little or no due process. And partially in response to these hardline tactics, protests broke out last week in Los Angeles. And now, inflaming an already inflammatory situation, the federal government has sent in the National Guard and, most alarmingly, the Marines. And the legality of using the military domestically is dubious at best. But how did we get here? Well, ICE had staged a series of raids around the city on the morning of June 6, targeting a Home Depot, a clothing store, and other places where day laborers look for work. Now, we've already covered this in depth in a video that we just recently released, so we're only going to provide a cursory summary here. According to later statements by Governor Gavin Newsom's office, these raids were done without notifying local law enforcement. And on the afternoon of June 6, David Huerta, the president of the California Service Employees International Union, or SEIU, the state's largest union, was accosted by law enforcement and arrested while protesting. Later that afternoon, demonstrators gathered outside of the LA detention center where Huerta and others were being held. The LAPD declared an unlawful assembly and deployed tear gas on the protesters. The next morning, when news of the raid at another Home Depot in a Latino-majority neighborhood spread on social media, a few hundred protesters gathered nearby. Law enforcement fired tear gas as protesters threw rocks and objects at the law enforcement vehicles and tried to set up a makeshift roadblock. Later that evening, around 100 protesters gathered in Compton, where some protesters lit fires, damaged vehicles, and threw stones at law enforcement. And in response that night, the city instituted a curfew. According to news media reports and statements by both Mayor Karen Bass and Governor Newsom, the protests were largely peaceful, with only isolated incidents of violence and vandalism. Nevertheless, at 7 p.m. on June 7th, the Trump administration bypassed Governor Newsom and announced that it would deploy the National Guard, claiming the protests were a, quote, rebellion against the United States. This marked the first time a U.S. president has mobilized military forces domestically without the request of the state's governor since 1965. At the same time, Defense Secretary Pete Hegseth also announced that 500 Marines at Camp Pendleton in California had been placed on high alert. Newsom immediately denounced the deployment of military troops, calling it illegal, immoral, and unconstitutional, and threatened to take legal action.
Well, I mean, look, Donald Trump has created the conditions you see on your TV tonight. He's exacerbated the conditions. He's, lit the proverbial match. He's putting fuel on this fire ever since he announced he was taking over the National Guard. An illegal act, an immoral act, an unconstitutional act.
But the Trump administration ignored the governor's objections and deployed around 300 National Guard members to the streets of Los Angeles on the morning of Sunday, June 8th. Governor Newsom's predictions were accurate, and the deployment of the troops seemed to escalate the situation. Thousands of protesters amassed in downtown LA. There were reports of vehicles set on fire and law enforcement officers firing projectiles, tear gas, and pepper balls at journalists and protesters. A few hundred protesters blocked Highway 101, and as tensions escalated, Mayor Bass and Governor Newsom both urged protesters to stand down and remain peaceful. By Monday, June 8th, the protesters appeared to calm, but ICE doubled down and raided several Home Depot locations across the LA metropolitan area. By Monday afternoon, Governor Newsom made good on his threat to sue the administration, and the state of California filed suit in federal court, arguing that President Trump had overstepped his authority and violated the sovereignty of the state of California and the Constitution. California asked Judge Charles Breyer of the Northern District of California to grant a temporary restraining order by Tuesday at 1 p.m., barring federal troops from engaging in civilian law enforcement in LA. Judge Breyer declined to issue a temporary restraining order by 1 p.m. on June 10th, and instead the judge opted to give the parties an opportunity to more fully brief the matter before he held a hearing on Thursday, June 12th at 1:30 p.m. On Tuesday afternoon, despite the apparent lull in the protests, and despite California's lawsuit demanding that the Trump administration withdraw the troops, Secretary of Defense Pete Hegseth posted on Twitter that, quote, approximately 700 active duty U.S. Marines from Camp Pendleton are being deployed to Los Angeles. The Associated Press reported that these troops would join the approximately 2,100 National Guard troops that were already on the ground there. And President Trump boasted on Truth Social about the deployment of the military, including the Marines, to LA, but declined to set a concrete timetable for when the troops would leave LA.
Will the National Guard be in California indefinitely? How long will they be there until you think?
Until there's no danger. It's easy. Look, it's common sense. You ask me that question. When there's no danger, they'll leave.
Only specifying the quote, when there's no danger, they'll leave. A top Pentagon official testified before Congress that the estimated cost of deploying all of these troops to LA would be roughly $134 million. Secretary Hegseth, though, struggled to articulate to Congress what authority the Department of Defense was using to justify this deployment.
It's about maintaining law and order on behalf of law enforcement agents who deserve to do their job without being attacked by mobs of people. And so we're very proud that the National Guard and the Marines are on the streets defending the ICE agents, and they will continue to do that.
Law and order is a civil function under the Constitution of the United States. Civil enforcement, law enforcement authorities, not the U.S. military. And
there's plenty of precedent for the U.S. military supporting law enforcement officers.
What your military is doing right now is laying concertina wire, guarding buildings, maintaining vehicles for other services. This is not only, I think, illegal, but also a diminution of the readiness and the focus of the military.
Now, Liz Dye already covered on this channel the legal issues related to the deployment of the National Guard in a video that we just released, because it's actually a distinct legal question. As a quick summary, Section 12406 allows the president to federalize the National Guard in certain limited circumstances. That is, he can turn state militias into soldiers under the command of the federal government, not under the command of the states. And as Liz talked about, the first circumstance when state militias can be federalized is when we're under a foreign invasion. The second circumstance is in a case of rebellion, and it doesn't seem like any of those appear to be relevant right now. But if you want a more comprehensive overview of the law with respect to the National Guard, we'll put a link down to the description to the video we just released. But right now, I want to focus on the deployment of the Marines, because that is a completely separate matter. Now, using the standing military to enforce civilian laws is generally prohibited under the Posse Comitatus Act. And because of the danger of military-civilian conflict, protections against military engagement with civilians are actually baked right into our Constitution. Abuses committed by the British Army against American colonist civilians were part of what led the founders to divide military power between Congress and the President, and to draft the guarantees in the 3rd, 4th, 5th, and 6th Amendments. But the Posse Comitatus Act at 18 U.S.C. 1385 states that, quote, whoever except in cases under circumstances expressly authorized by the Constitution or Act of Congress willfully uses any part of the Army, the Navy, the Marine Corps, the Air Force, or the Space Force as Posse Comitatus or otherwise to execute the laws shall be fined under this title or imprisoned not more than 2 years or both. Now, notably, the Coast Guard is not considered part of the military for the purposes of the Posse Comitatus Act, which unfortunately lends fodder for those that claims that the Puddle Pirates aren't real military. I'm sorry for the coastie erasure. But the law allows for congressionally created exemptions, and Congress has created a few, most notably the Insurrection Act, which we'll talk more about in a second. But Congress has also created exceptions for a variety of other specific scenarios, including some drug enforcement operations and domestic bombings. But over the years, Congress has also carved out some specific activities the military can participate in that don't violate the Posse Comitatus Act. Those include maintenance and repair, transportation, training, and surveillance support, and the provision of equipment and sharing of information in some circumstances. 10 U.S.C. 271, for instance, allows the military to, quote, provide to federal, state, or local civilian law enforcement officials any information collected during the normal course of military training or operations that may be relevant to a violation of any federal or state law within the jurisdictions of such officials. Section 272 allows the Secretary of Defense to, quote, make available any equipment, including associated supplies or spare parts, base facility or research facility of the Department of Defense to any federal, state, or local civilian law enforcement official or law enforcement purposes. But these sections all describe indirect support functions, not direct participation in civilian law enforcement. And federal regulations echo this distinction, prohibiting, quote, direct participation by a member of the Army, Navy, Air Force, or Marine Corps in a search, seizure, arrest, or other similar activity unless participation in such activity by such member is otherwise authorized by law. And in opposition to the state of California's motion for a temporary restraining order, the Trump administration claimed that, quote, plaintiff's objection based on the Posse Comitatus Act is equally misdirected. Neither the National Guard nor the Marines are engaged in law enforcement. Rather, they are protecting law enforcement consistent with longstanding practice and the inherent protective power to provide for the safety of federal property and personnel. Now, if indeed the military's activities were limited to protecting other law enforcement personnel or federal property, that would probably pass legal muster, but pictures in ICE's own Twitter posts certainly make it look like military troops in LA are directly participating in a wide variety of civilian law enforcement activities. And according to the state of California's motion for a restraining order, the military troops are, quote, holding a secure perimeter in communities around areas where immigration enforcement activities would take place and securing routes over public streets where immigration enforcement officers would travel. And despite the DoD regulations explicitly prohibiting members of the military from engaging in seizure or arrests, the commander overseeing U.S. military operations in Los Angeles has also claimed that troops deployed to the city have the authority to temporarily detain civilians. Now, as we'll talk about, not only does the Constitution still apply to state police officers, but it also applies to federal agents and members of the military. And there's no such thing as a temporary detention of civilians. If you're not free to go, that's called an arrest. And if this is true, that kind of direct involvement by the military would potentially create a real danger to civilians. As the state of California pointed out in its court filing, when military troops participate in these kinds of law enforcement activities, it greatly increases the chance of well-armed troops with weapons of war who will have physical confrontations with civilians. And this creates an especially dangerous situation because military troops, unlike regular law enforcement, or at least some of them, are trained to kill enemies, not necessarily to de-escalate or deal with recalcitrant or disobedient civilians. This was infamously illustrated in the Kent State shootings. As you might recall or have read in the history books, on May 4th, 1970, during a protest related to the Vietnam War, Ohio National Guard soldiers fired about 67 rounds over 13 seconds, killing 4 Kent State University students, wounding 9 others, and one of whom suffered permanent paralysis. But here, support for military use of force against civilian protesters in LA is coming straight from the president. According to former Defense Secretary Mark Esper, during the 2020 Black Lives Matter protests, President Trump inquired about whether the National Guard could shoot protesters in the legs. Former Secretary Esper reportedly objected to that possibility, and when questioned about whether he would fulfill a similar order, though, current Secretary Pete Hegseth refused to answer what should have been a really easy question.
In June of 2020, then President Trump directed former Secretary of Defense Mark Esper to shoot protesters in the legs in downtown D.C., an order Secretary Esper refused to comply with. Would you carry out such an order from President Trump?
Senator, I was in the Washington, D.C. National Guard unit that was in Lafayette Square during those events,
Would you carry out an order to shoot protesters in the legs?
I saw 50 Secret Service agents get injured by rioters trying to jump over the fence, set the church on fire, and destroy a statue.
That sounds to me that you will comply with such an order. You will shoot protesters in the leg.
And President Trump's public statements make it appear likely that Secretary Hegseth will eventually be faced with that kind of scenario. In a recent Truth Social post about LA protesters, President Trump said, quote, "If they spit, we will hit, and I promise you they will be hit harder than they've ever been hit before. Such disrespect will not be tolerated." And here's the part where I remind you that disrespect is First Amendment protected activity. But on Tuesday, in a speech at Fort Bragg, Trump continued to ratchet up his rhetoric, referring to the LA protesters as, quote, animals and foreign enemies. And the president even repeated the baseless conspiracy theory that Governor Newsom and Mayor Bass had funded the protests, saying, quote, "In Los Angeles, the governor of California, the mayor of Los Angeles, they're incompetent and they paid troublemakers, agitators, and insurrectionists. They're engaged in this willful attempt to nullify federal law and aid the occupation of the city by criminal invaders." Now, in its opposition filing, the Trump administration claims that civilians and protesters aren't the ones in danger. The law enforcement officers are, which is the justification it's relying on for the president's use of Marines and unilateral deployment of the National Guard. But despite the administration's rhetoric about invaders and enemies, it hasn't yet cited any authority justifying its deployment of Marines in Los Angeles. In its June 7th memo, the Trump administration claims that 10 U.S.C. 12406 gives it the authority to federalize California's National Guard. But even if that statute does justify the federalization of the National Guard, and that's a big if, it still won't justify the deployment of the Marines from Camp Pendleton. And the administration's opposition in California versus Trump engages in a similar sleight of hand using Section 12406 to justify the deployment of the National Guard, but offering no concrete legal justification for the deployment of the Marines. Instead, the administration relies on an obscure Office of Legal Counsel memo by William Rehnquist, in which Rehnquist, then the head of the Office of Legal Counsel, opined that, quote, "The Posse Comitatus Act does not impair the president's inherent authority to use troops for the protection of federal property and federal functions, nor does it prevent the use of troops to protect the functioning of the government by assuring the availability of federal employees to carry out their assigned duties." Now, a memo from the Office of Legal Counsel can be persuasive, but it's not binding on the courts. It basically represents the opinion of the executive branch. But other than that, the only legal authority the Trump administration cited for its California versus Trump brief is dicta from 2 late 1800s era Supreme Court cases. The Trump administration cites In re Nagel, an 1890 case, to support the proposition that the president has the authority to protect the mail service and mail carriers with Army soldiers or U.S. Marshals. But Nagel had nothing to do with the Posse Comitatus Act. It was a habeas corpus petition by a U.S. Marshal who was being accused of murdering because he had killed a man in the line of duty while protecting a circuit judge. And the idea of Posse Comitatus, not even the act itself, was mentioned only in passing while the court was evaluating the marshal's justification for the killing. The Trump administration then cites In re Dobbs, an 1885 case, to support its argument that, quote, the strong arm of the national government may be put forth to brush away all obstructions to the freedom of interstate commerce or the transportation of the mails. If the emergency arises, the army of the nation and all its militia are at the service of the nation to compel obedience to its laws. But again, Dobbs had nothing to do with the Posse Comitatus Act. In Dobbs, the Supreme Court considered whether the federal government had the authority to issue a legal injunction against a union that was blocking all railway traffic in the city of Chicago. Notably, in that case, the government was not addressing the problem by force, military or otherwise. It was seeking to enforce a court's injunction. The Posse Comitatus Act wasn't even mentioned in the case because it had nothing to do with the legal issue the court was considering. And that's it. That is literally all the legal authority the Trump administration is currently citing to support its deployment of Marines to a major U.S. city to combat a few vehicle fires and the very temporary blockage of a freeway. But who knows? This Supreme Court has taken an extremely expansive view of presidential power, and maybe it will find these arguments of inherent and unenumerated powers of the Constitution to the executive to be persuasive. I wouldn't take bets on this. But unfortunately, President Trump has not so quietly signaled that he intends to invoke a far more troubling authority, the Insurrection Act, which could potentially qualify as a congressionally created exception to the Posse Comitatus Act. Now, if you try to commandeer the National Guard or the Marines, you're probably going to want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you've got a data breach letter saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. Now, the Insurrection Act of 1807 is actually an amalgamation of different statutes enacted by Congress between 1792 and 1871. One can surmise it was written for another time. But Section 251 of the Insurrection Act allows the president, at the request of the state, to deploy troops to that state to quell violence in that state. It reads, quote, whenever there is an insurrection in any state against the government, the president may, upon the request of its legislature or of its governor, if the legislature cannot be convened, call into federal service such of the militia of the other states in the number requested by that state, and use such of the armed forces as he considers necessary to suppress the insurrection. So Section 251 expressly requires state consent for that kind of deployment. But Sections 252 and 253 of the Act allow the president to deploy troops even if the state does not consent. Section 252 permits deployment whenever unlawful obstructions, combinations, or assemblages, or rebellion make it impracticable to enforce federal law in that state by the ordinary course of judicial proceedings. And Section 253 has two parts. The first allows the president to deploy the military in a state if the state's inhabitants are being deprived of a constitutional right, and the state authorities are unable or unwilling to protect that right. This section was used by Presidents Eisenhower and Kennedy to desegregate schools in hostile states. And the second part of Section 253 permits the president to deploy troops in a state that, quote, opposes or obstructs the execution of the laws of the United States or impedes the course of justice under those laws. Now, those sections don't require consent, but they still require certain circumstances to justify the deployment. And the Supreme Court has had a history of being deferential towards the president's choice to declare that there's an emergency warranting a military involvement. In Martin v. Mott, an 1827 Supreme Court case, the court held that, quote, the authority to decide whether an exigency requiring the militia to be called out has arisen belongs exclusively to the president, and his decision is conclusive upon other persons. Still, the Insurrection Act has rarely been invoked, probably because it's considered a very powerful tool, and the idea of military troops deployed in the streets against U.S. civilians is deeply troubling. According to the Brennan Center, in 230 years of U.S. history, the Insurrection Act has only been invoked 30 times. The first was in the Whiskey Rebellion, and the latest was in the 1992 Rodney King riots, also in Los Angeles. And I probably don't need to say this, but I'll say it anyway. The Insurrection Act, even if used, still doesn't allow the president or the military to abridge the constitutional rights of protesters. So as much as he might wish to, President Trump cannot silence free speech or bypass the First Amendment just by declaring that there's an insurrection. But he may still try. According to the New York Times, in Trump's first term, White House aides even drafted a proclamation to send thousands of active duty U.S. troops into the streets. But President Trump was ultimately talked down by Joint Chiefs Chairman General Mark Milley and Defense Secretary Mark Esper. But it seems unlikely that Secretary Hegseth or anyone else in the current Trump administration will take a similar stand. And it seems that Trump is now poised to invoke the act. In recent days, President Trump has openly labeled the LA protests as an insurrection and called the protesters violent insurrectionist mobs.
How will you determine whether or not there is an insurrection?
Well, you'll take a look at what's happening. I mean, I could tell you there were certain areas of Los Angeles that you could have called it an insurrection.
And that's echoed in legal filing in California versus Trump, where the Trump administration once again used the term saying, quote, "It is well established, however, that when the president lawfully federalizes the National Guard pursuant to statutory authority designed to authorize the use of the militia to restore order, the Posse Comitatus Act does not apply. One such exception is contained in the Insurrection Act." Though the administration stopped short of claiming that it was invoking the Insurrection Act to justify the deployment of the Marines in that case, mentioning the act only by name, but using the term insurrection in so many other related circumstances doesn't seem accidental. But you can see the give a mouse a cookie aspect to the use of the military here. ICE needs to be protected, so they call in the National Guard, and the National Guard needs to be protected, so they call in the Marines. But if indeed the Trump administration has violated the Posse Comitatus Act, there could be legal consequences beyond just the pending lawsuit with the state of California. And as we've talked about many times, the president himself is unlikely to face those consequences because of presidential immunity. However, the Posse Comitatus Act specifies that anyone who violates the act can be fined or sent to prison for up to 2 years. So it's possible that members of his cabinet or the people with boots on the ground might still be held accountable if they violate the act. And if there is a confrontation between military troops and civilians that results in civilian death, that could also create significant liability for the U.S. government. For example, in a case called Schuer versus Rhodes, a civil case filed by the family members of the students slain in the infamous Kent State shooting, the Supreme Court ultimately ruled that the government officials could be sued for monetary damages. And on the evening of Thursday, June 12th, after holding a hearing and considering the parties' motions, Judge Breyer of the Northern District of California granted a temporary restraining order in favor of the state of California, barring the Trump administration from deploying the National Guard in Los Angeles and returning control of the Guard to Governor Gavin Newsom. The court considered the plaintiffs' claims that President Trump was exceeding his authority and violated the 10th Amendment. Plaintiffs had argued that by deploying troops to LA without Governor Newsom's consent, Trump had exceeded his lawful authority in 3 ways. First, although Trump cited 10 U.S.C. 12406, which permits the president to federalize the National Guard, none of the 3 statutory conditions for invoking that statute were met. Second, he failed to comply with Section 12406's procedural requirement that any order issued under the statute, quote, shall be issued through the governors of the states. And third, he federalized the National Guard for an unlawful purpose in violation of the Posse Comitatus Act, 18 U.S.C. 1385. Judge Breyer first considered each of the 3 statutory conditions, which could permit President Trump to federalize the National Guard under Section 12406. 1, the United States or any of the Commonwealths or possessions is invaded or is in danger of invasion by a foreign nation. 2, there's a rebellion or danger of rebellion against the authority of the government of the United States, or 3, the president is unable with regular forces to execute the laws of the United States. Judge Breyer concluded that the first condition, an invasion by a foreign nation, was not relevant here. He then considered whether there is a rebellion, and obviously the Trump administration has been trying to claim that the Los Angeles protests qualify as a rebellion, but Judge Breyer wasn't having it. He harshly criticized the administration for implying that legitimate First Amendment protected protests could be classified as a rebellion just because a few bad actors engaged in isolated incidences of violence or vandalism. Judge Breyer wrote, quote, in short, individuals' right to protest the government is one of the fundamental rights protected by the First Amendment, and just because some stray bad actors go too far does not wipe out that right for everyone. The idea that protests can so quickly cross the line between protected conduct and rebellion against the authority of the government of the United States is untenable and dangerous. Judge Breyer then turned to the third condition, that the president is unable with regular forces to execute the laws of the United States. Judge Breyer pointed out that this is obviously not the case since ICE continued to make arrests throughout the protests. In fact, ICE had managed 44 arrests on June 6th. And Judge Breyer contrasted this against the 1970 mail service strikes, which shut down the entire postal service. So in light of this, Judge Breyer concluded that none of the 3 statutory conditions for federalizing the National Guard had been met. So he next considered whether the Trump administration had met the procedural requirements under Section 12406, which requires that the order to mobilize the National Guard must be made, quote, through the governor. And Judge Breyer rejected the Trump administration's laughable argument that because the administration had stamped through the governor of California, on top of their Department of Defense orders, they had satisfied the requirement. Seriously, I'm not making this up. That actually was the Trump administration's argument, that simply by putting those words on the top of the memo, that magically satisfied the requirement to mobilize the Guard through the governor's office. And the administration also tried to argue that they didn't actually have to go through the governor himself, they just needed to go through the commander of the California National Guard. Judge Breyer wasn't having that either, and because neither of these conditions had been met, Judge Breyer ruled that President Trump had operated outside of his authority, and the judge declined to adjudicate what might have happened if the administration had instead actually sought Governor Newsom's consent and not been able to attain it. And Judge Breyer also declined to rule on the question of whether the Trump administration had violated the Posse Comitatus Act, because that requires a factual adjudication, which will take place when the court considers the motion for a preliminary injunction over the coming weeks. Now, finally, Judge Breyer considered whether the Trump administration had violated the 10th Amendment, which states that, quote, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." Now, traditionally, states' rights arguments have often been made by Republicans and Libertarians, but in a strange turn of events, it's now Democratic California that is making an argument and the Republican Trump administration that is fighting against it. But Judge Breyer ruled that the Trump administration had clearly violated the 10th Amendment, finding that, quote, "It is not the federal government's place in our constitutional system to take over a state's police power whenever it is dissatisfied with how vigorously or quickly the state is enforcing its own laws. Quite the contrary, the founders reserved that power and others to the states in the 10th Amendment." So the court granted the TRO against the Trump administration in joining the use of the National Guard. But the Trump administration, of course, immediately appealed, asking the Ninth Circuit Court of Appeals for a stay, and the appeals court granted that stay without comment. It used to be the case that TROs were not immediately appealable, but that appears to not be the case anymore. And this is also the most recent example of Trump pulling an extremely friendly panel of 3 judges, mostly Trump-appointed judges, which is statistically unlikely, but it unfortunately keeps happening. But that is just an administrative stay during the pendency of the appeal. But this won't be the end of the military deployment. He has vowed to continue his war on cities, specifically posting, quote, "We must expand efforts to detain and deport illegal aliens in America's largest cities, such as Los Angeles, Chicago, and New York, where millions upon millions of illegal aliens reside. These and other such cities are the core of the Democratic power center, where they use illegal aliens to expand their voter base, cheat in elections, and grow the welfare state." So the unhinged crazy continues. Now, if you'd like to support this channel and its mission to demystify the legal miasma that we currently live in, one way to do so is by signing up for our homegrown streaming platform and sponsor, Nebula, because you can watch all of our videos on Nebula ad-free and early, because our videos always go up on Nebula first. Plus, every video we upload to Nebula this year is an extended cut featuring additional analysis and commentary that you can't get on YouTube. And in particular, this channel has been increasingly demonetized this year on YouTube because we keep having to cover things that are not necessarily advertiser friendly. For example, our recent video on how the government cannot legally deport citizens was demonetized on YouTube because it showed a single image of the World Trade Center on 9/11. That was a mistake by YouTube and it was eventually taken care of, but we lost a huge amount of revenue because of YouTube's mistake. And people often ask if it helps the channel more to watch it on YouTube or Nebula, and the answer is emphatically on Nebula. The watch time payouts are bigger, and since my creator friends and I created Nebula ourselves, we don't have to worry about capricious demonetization standards. Which is why we put tons of exclusive content on Nebula, like our video on how RFK Jr. can and cannot legally ban vaccines, and our video on unhinged judges that went too far. That content probably wouldn't work on YouTube, or it might get demonetized, so it's only available on Nebula. Plus, instead of sponsorships like this one, we always add additional analysis and commentary to the end of every video, or at least some group therapy. So if you'd like to sign up, you can get 40% off your annual subscription, a year of the best content for just $36, or you can even gift that to a friend with a Nebula gift card. Or you can check out the lifetime subscription, where for $300 you get access to Nebula forever. But either way, you can get Nebula by clicking on the link below. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.